imagine a program whereby there's no chairperson. Now this chairperson in particular will intrigue you. Now the chairperson is not just the star of the show, but he's there to enable the show to shine. It is in this regard that I and Estre has been given the singular honor of introducing the chairperson for this occasion. Today's chairperson is known for his work in humanitarian aid, and at the mention of his name, the virtues of hard work, determination, persistence, and willingness pop up. He's a barrister by profession and works as a legal officer for the University of Cambridge. He also has the additional responsibility as a coordinator for institutional advancement services, a role that requires him to develop individuals and corporate network, which I would say has been perfectly executed over the years. This fascinating individual has degrees from the University of Ghana, joint degrees from Norway and Finland, as well as Portugal, so he's very learned. He also has a Master's of Law from the University of Toronto. On a final note, he teaches as a sessional lecturer at undergraduate and graduate levels. Known for his positive and motivational attitude towards work, his dynamic range of acquaintances and a sense of adventure which knows few bounds. Ladies and gentlemen, invited guests, it is a great pleasure, great honor, I introduce to you the chairman for this occasion, audience, your chairman.
Please, be kindly.
Hello, please, be kindly seated. Mr. Estre, thank you very much for your very kind words. I don't know where you got all that from, but I'm very grateful. It is with the sincerest humility and honor that I accept to share this very function. Let me take the opportunity to warmly welcome all of you. And let me say that this program is a well-established tradition of the UCC LSU Law Week. It seeks to generate and disseminate knowledge in thematic issues in the field of law. Today's topic for discussion is human rights advocacy in the 21st century, the lawyer's perspective. And the selected speakers include no other less person than His Lordship Justice Chiba, who through date of hard work has moved from the lower court, circuit court, through the high court to the Court of Appeal. Mr. Chamberlain, is my Lord Chamberlain, I think he has taken a short break, but may I put on record that his selection to deliver, to speak on this legal luminaries platform is a recognition of his distinction in his various stations in life as a judge, as a law academic, and as a practitioner. I have no line that in line with his status as a legal luminary, his presentation will inspire greatness and greatness in the audience today. I will want to take the synopsis together with my opening remarks. So consider my opening remarks close at this stage. I'm now giving the synopsis for the sake of time, so that we don't spend too much time here. Now, the latter part of 2020 and 2021, this year, what I call the coronavirus years, has produced many events which have shook the philosophical and legal basis of human rights in Ghana. We know that in March 2021, for example, two young male two young students of Fatima School by the name of Tyrone McGuire and Oniba Nkrabia, both students of Fatima School, were required to start their rasta the war before they are admitted by the school. Their enrollment essentially was made subject to day 13 their heads. Dissatisfied with this decision of the school, they brought an action at the High Court to enforce their fundamental human rights and Article 3, specifically the right to manifest their religious belief and also their right to education. The court upheld the claims of the students and ordered the school to admit them. What the judge masterfully did, the High Court judge masterfully did, was to demonstrate or show that the respondents had failed to properly bring themselves within the justifications for limiting or curtailing human rights. Now, this, however, does not end the controversy, because what the judge was not clear about was the very scope, context of the right to manifest the religious belief. For example, what we do not know from the judgments is the extent.
Can you hear me?
Yes, we can. The extent to which school rules in themselves will constitute a public interest right now for limiting religious rights. In May 2021, the famous Sweet Ghana West Girls High School became a subject of national conversation following allegations that they have banned Muslim students from performing their annual fasting rituals. It took the intervention of the Ghana Education Service Peace Council and some civil society groups to restore an uneasy calm. Here again, the right to freely exercise one's religion meant the resolution of the problem that Muslim students who choose to enter a Christian mission school should not be constrained in any way from practicing their religious belief. Now, this solution, however, in my view, requires further clarity, as it is not without questions. For example, as the Strasbourg courts have observed, if you follow the EU human rights jurisprudence, I'm talking about the European Court of Human Rights and the European Court of Justice, where a person has voluntarily accepted to enroll in a school or employment which does not accommodate his religious belief or practice or observance, and there are or where other means to that person to practice his religion without hardships, the court will not be ready to find interference. How the court will react to a scenario such as the Western Girls case is yet to be seen. But certainly the facts seem to provide for that, for legal controversy. Finally, I cannot end by wading into the controversy of the LGBTQI debate. In July 2021, we have witnessed some legislative efforts that seek to regulate sexual behavior and even to some extent criminalize what has come to be known as lesbian, gay, bisexual, and transgender, queer, and others. The strongest argument for criminalizing this behavior have been that it is unnatural, it is Ghanaian, it is anti-cultural, and it's simply immoral. The strongest argument against has been that LGBTQ persons are also human beings, endowed with the inalienable rights of sexual expression like any other human being, and that as minorities, we also deserve to be protected. The fundamental question that underpins this controversy, in my view, however, remains: one, at the broad philosophical level, are humans generally biologically or inherently predisposed to a particular mode to means of sexual expression or human sexual expression? In other words, did God create human beings from the, if you have a religious setting, to express his or her sexuality in a particular way? In the realm of legal philosophy, a more precise question would be: should the law be concerned with sexual behavior that does not potentially harm others and which is consensual? In other words, should the law be concerned with what people do in their bedrooms if what they do does not harm others? Now, in the more legal, from the more legal lens, one may ask the question: how does this play into the broad context of what we call unenumerated rights in Article 33 of the 1992 Constitution, as well as the many international human rights instruments ratified by Ghana, which either directly or indirectly protect the right to self-identification and to sexual expression? These and many issues, in my view, may dominate our minds as lawyers and jurists as we plow this complex minefield called human rights. On this note, I end my remarks and synopsis. And see that I anticipate we will be treated to answers to this question by our very eminent and respected jurists, which we have here assembled. Thank you very much. We will proceed the UCC answer.
There is no The chairman for the occasion, His Lordship Eric Chebafo, and as Kofi Abochi, Dean, UPSA, Dr. Benjamin Kumbo, invited guests, my dear students, our friends from the media, ladies and gentlemen. I bring you greetings from the university management, particularly from the Vice Chancellor of this great institution. He wanted to be part of this important occasion, but unfortunately, he has to be out of Cape Coast. Therefore, I find myself lucky to represent him during this occasion. On my own capacity as a provost and part of this occasion, colleagues, ladies and gentlemen, my dear students, the topic for today, human rights advocacy in the 21st century, the lawyer's perspective. As law students, I think this topic is crucial and topical for our profession. You agree with me that human rights is one of the foundations of our dear profession. I went back to look at the genesis of human rights advocacy. It took me to 2015, Magna Carta 2015, the English Bill of Rights 1689, the French Declaration on Rights of Man and Citizens 1789, U.S. Constitution and Bills of Rights 1791, and it's also take us back to Thomas Hobbes, which borders on exchange. The citizens exchange their rights for government to guarantee them safety and rights. So human rights is very essential. Right to life. All human beings deserve the right to live. Right from inception, when we are in our mother's tummy, the right protects us, that we have the right to live. And our parents don't have the right to abort us. So it's fundamental. The right to health, the right to education. Our chairman just mentioned what happens in our Timothy school. Right, having education is a right. Freedom of speech. The right to recreation. We can mention them. And it is our duty as lawyers to defend, advocate, so that human rights prevail. But we find ourselves in an era, the 21st century, we are aware of some abuses. And as lawyers, as future lawyers, we have to accept that it's our duty to fight, to advocate for the right of citizens and humanity in general. Today, we have assembled here to contribute to advance on this cause. So Our gathering this morning is to contribute in order to advance the cause of human rights. And as lawyers, we have to champion it. So today I'm happy that I'm part of this important occasion, and I'm ready to listen and learn. So thank you for the opportunity.
Good morning. I'm elated and humbled to be given this opportunity to introduce the first speaker or the keynote speaker for our legal luminaries. The speaker is a justice of the Court of Appeal, Accra. He is a product of the Faculty of Law, now School of Law, University of Ghana, Legon, where he obtained his law degree. He was also called to the bar as a barrister at law and solicitor of the Supreme Court of Ghana 20 years ago. He holds LLM in both private and international law from St. John's University School of Law, Queens, New York, USA, where he merged with magna cum laude in his class. He has been a judge for over a decade now, having started his career on the bench in 2010 as a circuit court judge, and 3 years later, by dint of hard work, as a justice of the High Court, Tema, and later Accra. He has presided over some of the landmark cases in Ghana, including Papa Kisindu versus Salotite and Electoral Commission, an epoch-making judgment that paved the way for some of the disqualified candidates in the 2016 presidential election to gain qualification. His decision at the High Court was substantially affirmed by the Supreme Court. His recent decision in the case of the Republic versus Eugene Bakokoni helped the Supreme Court to lay down rules on discovery and inspections in all criminal cases in Ghana. He is a former senior lecturer at the Central University, having lectured in criminal law and also jurisprudence and legal philosophy. He is currently a senior lecturer at the Ghana School of Law in Pakamus, lecturing in the law of interpretation of deeds and statutes for Part 2 professional law students. He is also a former National Secretary of Association of Magistrates and Judges of Ghana. From 2016 to 2019, he was the representative of justices of the High Court to the Judicial Council, the highest constitutional decision-making body of the judiciary of Ghana. He is the director of the Complaint and Inspectorate Unit of the Judicial Service, which is the anti-corruption wing of the judiciary. He presides over a number of disciplinary investigations in the Judicial Service. He is married with 2 lovely daughters. Join me with a round of applause in welcoming our keynote speaker to deliver a speech for today's State Legal Luminaries, who is no other person than Justice and a justice of the Court of Appeal. Thank you.
Please, you may resume your seat. And thank you very much. The chair for this occasion, the rep of the Vice Chancellor, Professor Eric Amwako Ando, Dr. Benjamin Kumbuo, my good friend, Professor Kofi Abuchi, who have joined us via Zoom, lecturers here, the President of the Law Students Union, members of the university community, students,
ladies and gentlemen, greetings to you all. I am grateful to you all, to the leadership of the Students' Union, for the invitation extended to me this morning to deliver a speech on human rights. And I must confess, I have enjoyed the talk from Dr. Kumbuo and also from Professor Kofi Abuchi. I think they have done justice to the topic, and I have enjoyed their deliveries. When I was invited to speak this morning, I was asked to speak on the topic human rights advocacy in the 21st century, the lawyer's perspective. I do not intend to stray too much from this topic, but I have decided to tweak it a bit to add some flavor and yet achieve the same end. And on that basis, I have turned the topic into what I have captioned: law, religion, human rights at the crossroads in Ghana. Law, religion, human rights at the crossroads in Ghana. The perspective of the jurist. Religious right is a component of human rights, and they are all subsets of the law. And religious right now in Ghana appears to be an aspect of human rights that is posing one of the greatest challenges to us as a nation. And I was happy in the remarks of the chair when he did mention some of the religious rights issues confronting this nation. And I have changed from the lawyer's perspective to that of the jurist to ensure we have a much more comprehensive view of all in the legal fraternity, whether being a lawyer, a judge, a law lecturer, or an expert in the law, whose perspective must be recognized. The law, religion, and human rights are the crossroads. And I believe there is no better opportune time to deal with this than now, because we appear to be grappling with the bounds and the remit of matters of freedom of religion, belief, conscience, and expression as manifested in the ongoing construction of the National Cathedral, state support for religious pilgrimage to Mecca, compelled religious worship in some second cycle institutions, especially the traditionally mission schools, the annual ban on drumming and dancing, controversy in the Gas State, the claim of religious exemption to the salutation of national flag, the singing of national anthem, the recitation of the national pledge by the Jehovah's Witnesses, the claim by Rastafari religion of an infringement of their rights as far as keeping of dreadlocks are concerned in schools by Rastafari students, call for an exemption to the use of some psychotropic substances that are considered illicit under our laws. But some religious groups think it is part of their religious worship. And the issue of national prayers, the pouring of libation in national programs, and where atheists, humanists, agnostics consider to be a slap in their face as they feel excluded And also some Muslim students with respect to the wearing of the hijab in some schools where there have been attempts for their removal. And I believe with all these issues confronting us and with the claim of human rights involved, I think this is the right time for us to begin to discuss some of these issues. As we all know, what rights are for which humans are entitled to have is seen as a bundle of claims, privileges, power, and immunity. So it can encompass a whole lot of claims. In other words, to have a right to property is to have a claim to that to have a claim to that property. And so a person can say, I have a claim to this. That may be a human right. To have a right to information may be one of a privilege. A privilege that one may be denied on the basis of lawful justification. The right to life, as the earlier speakers have asserted, may be one of a claim to immunity from death or deprivation of life through any unlawful action. That it is inalienable. I have the right to live, and I am immune through the actions of the state or any other person from death. And in that sense, when we are dealing with right, it is an immunity. You are immune from such. So for such claims, privileges, and immunities to be interfered with, it must be done in accordance with law. And there must be in existence similar rights of other persons or in the public interest. And so where there are no such justification, competing interest, that will necessitate that such claim must be curtailed, then there will be no justification for any violation or infringement of these rights. And so it is possible for a right to be a claim, to be a privilege, to be a power, to be an immunity. And so this morning, as we are dealing with human rights, it encompasses a broad spectrum of issues that we are discussing. Okay. We know all these rights have been guaranteed in Ghana in our constitution, the 1992 constitution. And Professor Abochi even referred to Article 33 of the constitution. That the rights that are not specifically mentioned in the constitution does not mean they have been excluded. And if Ghana is a signatory to any international convention or declaration regarding human rights, and that right has not specifically been mentioned, then it means it is also part of the rights that is accorded persons living in Ghana. I don't need to go through all the various rights we have entrenched in our constitution. But when you read from Article 12 all the way to 33, the constitution specifically mentions the rights that citizens of this nation are entitled. There are many. But when it comes to issues of religion, it encompasses a lot in terms of thought, conscience, the right of belief, and the right to manifest one's belief. Indeed, you can believe anything, that is your belief. But in terms of manifestation, usually there are some restrictions in respect of your right of manifestation. And I think we would discuss a little bit of that this morning. Okay. Under the Constitution, where the human rights of a person or a citizen is violated, or there is an allegation of a breach of that right, per the interpretative processes of the Supreme Court, one has to ventilate or proceed to the High Court for the enforcement of that human right. But where one is alleging a violation of, say, a human right, not in respect of him or herself, but generally in respect of a breach of an aspect of the Constitution, then in terms of Articles 2 Clause 1 and Article 130 Clause 1 of the Constitution, the forum then will not be the High Court, but rather the Supreme Court. So any alleged infringement or violation of your rights in relation to you personally, the forum then will be the High Court. In respect of any alleged violation of any rights guaranteed under the Constitution, not personally against you, but the state or anybody that have violated it, then the forum will have to be the Supreme Court for a declaration or for an interpretation as to the rightfulness of the action that is being taken. And I think Professor Abochi did mention the issue of this LGBT rights issues that is now on the front burner. I believe the rightfulness of the actions that are underway in terms of the bill before Parliament and its passage. Probably some may have to wait after the passage of the bill into law for the constitutionality of that law, when passed, to be tested at the Supreme Court. Because per Article 2 Clause 1 of the Constitution, it is the Supreme Court that has the final say to determine whether any act of Parliament passed by the legislature is in conflict or in contravention of the Constitution. And if indeed in interpreting the provisions of the Constitution with respect to sexual orientation, it comes to the conclusion that indeed it is a violation of the Constitution, the Supreme Court has the power to strike down that law that will be passed or any aspect of the law as unconstitutional. And we have seen it in a number of cases, J. Ampofo versus AMA, and then others. But for me, this morning, one issue before basically turning to the religious angle, that as human rights advocates, that we appear not to be giving much attention to, is in respect of what the Constitution terms as the directive principles of state policy. The directive principles of state policy under the Constitution consist of ideals, aspirations as to the goal of the nation. And so they are a body of economic, social, cultural, educational package that we find in the Constitution spelled out. The right to job, the right, and most of it, when you read, we say is aspirational. And the question for the jurist or for the lawyer who is an advocate for human rights is that how do we deal with it? You have completed university and you've been home for a number of years. Is there any right you can assert under the Constitution for the state to provide you with job, that the policies the nation has set in motion or the government is implementing is in such a way that it is giving blasted hopes to the young people of this nation. And the state must be directed to focus on such and such policies under the directive principles of state policy. And so the directive principles of state policy, they are aimed at realizing the ideals of justice, liberty, equality, as set out in the preamble to the Constitution. Originally, the committee of experts who drafted the Constitution never intended that the directive principles of state policy should be enforceable. That probably you don't have a job. The government is not running the state in such a manner as to ensure that the graduates coming out of our universities on annual basis are afforded the opportunity to give up their best in terms of employment. It was the view of the drafters of the Constitution that this should not be, that you cannot read any aspect of the directive principles of state policy, and where there is a breach or a violation or the government is not complying with that, then you proceed to court. But one interesting aspect is that in the final draft of the Constitution, the recommendation that the directive principles of state policy should not be justiciable was rejected and did not become part of the Constitution. And so, as to whether or not you can go to court in terms of those directive principles of state policy being aspirational or being an enforceable right, has engaged the Supreme Court since, I think, 1994. So the first case, we had this MPP versus Attorney General, SIBA case. The Supreme Court was confronted with the issue as to whether or not the directive principles of state policy in terms of economic, social, political rights spelled out can be enforced. It was the decision of the Supreme Court that where any of the rights stated under the directive principles of state policy happens to coincide with any other right in other aspects of the Constitution, then it becomes a justiciable right for which one can come to court. That was what the Supreme Court decided in the SIBA case. Therefore, the directive principles of state policy to be justiciable in court, then we must find the same right repeated in other aspects of the Constitution. But before then, there had been another decision, also in the case of the MPP versus Attorney General. That is the 31st December case. And it was the opinion of the court that the Constitution, reading it from cover to cover, every aspect of it is justiciable. Otherwise, then there will be no reason or purpose for the framers of the Constitution to have included that in the Constitution. So whether directive principles of state policy or not, every aspect of it is justiciable. But we had the last case, and that is the case of Ghana Lotto Operators Association versus National Lottery Authority. And it concerned itself with Act 722. That more or less gave monopoly to the national lotteries to organize lotteries. And there was a challenge that for the private operators, it was an infringement of their economic right and freedom to also be in any business they wanted to be, including lotto operation. And in this case, Justice Databa looked at the original intent of the framers of the Constitution and rejected the original intent and made it a point that presumptively the directive principles of state policy are justiciable. Presumptively. In other words, we must look at it depending on the context and the basis for which an applicant has come to court to enforce any aspect of the directive principles of state policy, and looking at the strength, probably economically, of the nation as to whether or not, in terms of reasonableness, this should be a right for which the court should enforce. But all these cases more or less dealt with the question of justiciability, but not really one of enforceability. And there may be some differences between the two. They may not be the same. The justiciability, yes, can you come to court? And the question of enforceability, has the court the power to compel obedience of the state in terms of any finding of an alleged violation or infringement of any aspect of the directive principles of state policy? So for me, the burning question is, how far have advocates within our courts taken the challenge towards the enforcement of the rights spelled under the directive principles of state policy? So in the face of graduate unemployment, redundancy, retrenchment that has been exacerbated by recent crisis in the banking and financial sectors of the economy, economic inequalities, housing deficit, lack of proper and decent accommodation for a greater number of the population, the need to test the enforceability of such rights under the directive principles of state policy has never been more pronounced than now. So until the frontiers of the law are tested, its boundaries cannot be expanded or moved, and will continue to be held in within the little closet of successes achieved. And so for the advocate, this is a big challenge for the advocates to take it up in terms of challenging and seeking the pronouncements of our courts as to the directive principles of state policy, the rights spelled out regarding its enforceability. Let me now turn my attention and speak in respect of right claims in relation to religious rights and its enforcement before our courts. There is a tendency, probably in the early years of the development of the law, to see law, ethics, and morality as one. And indeed, in the early years of its development, that is how it was seen. What was moral, what was ethical, was law, and what was law was something that was moral and ethical. And even that is how the common law developed. So we had people like Blackstone, William Blackstone, who asserted that Christianity was part of the laws of England. But with the development of society and modernism, then we begin to see a sharp distinction between what is law, what is morality, what is ethics in that regard, so that the religious circle or religion operates within its own circle, whilst that of the state concentrate on making laws that are neutral but not specifically generated from religion. And so for students of law that love jurisprudence, that takes us to the positivism, where positivists begin to see law as it is, but not colored by ethics, morality, religion, or any of those. And indeed, for the positivists, they don't see those as law. And so we had Kelsen and others in his theory of propounding what he calls the pure theory of law, or the pure science of law. And so historically, the cord that the law had with religion at some point begins to break. And that is the context I want to deal with, the issue of religious rights and the claims we have in this nation currently in respect of human rights, the push from the religious angle, and how do we deal with some of these issues. When you look from Articles 21, it guarantees the freedom of religion, of belief, of conscience. As to what specifically this means, its remit, its scope, I must say we are yet to do it. But there are other jurisdictions that have gone far in the determination of this. And specifically, I'll refer to the United States. In their first amendment, they stated that the state shall not get itself involved in matters of religion, establishment, we call it the Establishment Clause. And so the state was supposed to be neutral in respect of religious claims. And basically that was informed by their history. Because the early settlers from England and Europe had moved to the 13 original colonies of America. And their purpose, number one, was to escape that kind of religious wars, confusion that had decimated Europe in the Middle Ages. If you were to take England, for instance, they had the Church of England dominating social, political life. And so for many that wanted a break, they saw America as the place for them to be. So guided by their history, in their first amendment to their constitution, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Over the years, in cases like Marsh versus Chambers, Lynch versus Donnelly, and others, they have interpreted this. Some of them where probably a National Assembly opens its session with a national prayer, they had interpreted this to mean that the history of their founding fathers, that was what they used to be, they used to do, and they never thought that this was any entanglement, the term they use, entanglement of the state with parochial religious matters. But for Ghana, the first test case on religious rights or freedom was the case of Kwabena Bomfe versus the Attorney General. In this case, the plaintiff, that is Bomfe, sought a number of reliefs or declarations from the Supreme Court that the construction by the state of a national cathedral, or what is called a mother church, was an infringement of certain articles, including Article 21 of the Constitution, because it meant that the state or the nation was supporting a certain religious group, Christianity, as against others who are not Christians, or even others who are agnostics, who don't believe whether God, who don't know whether God is there or God is not there, or atheists who don't have any belief in God. And that was discriminatory. It was part of the relief it sought. The Supreme Court in its decision noted that those articles, that is Article 21, 35, 37, and mind you, some of the articles 35, 37 are within the directive principles of state policy. There was no issue of interpretation for the Supreme Court to interpret. And so, issue of the construction of a national cathedral, the state support to Muslims that on regular basis take a pilgrimage to Mecca, to the Supreme Court. That issue did not raise any question of interpretation. And indeed, when you read the Kwabena Bonfe case carefully, he uses the word excessive entanglement with religion. That the nation was excessively entangling itself with religion. And that is a phrase he lifted from American discourse, where the state is not supposed to use the word entangle itself with religion. But we must note, within the context of the United States, there were two positions that sought a separation of the state from religion. That is the politicians led by Thomas Jefferson and a religious man, Roger Williams, who founded Rhode Island. They all wanted, but for different reasons. Roger Williams wanted to separate Christianity from any interference from the state. He did not want that. They wanted to worship their God in peace without any interference, like what they experienced in England from the Church of England. On the other hand, Thomas Jefferson and others also thought that if they allowed Christianity or religion to interfere in national life, political life, they had a tendency to also corrupt the state in terms of the dictatorial tendencies of religious bodies. So they all wanted separation, but for a different reason. In Ghana, some of the terms that the Supreme Court in the Bonfe case found not to raise a question of interpretation, like issue of questions or terms like secularism, pluralism. The court just stated them, but it did not delve into what they meant and what they did not mean. For instance, secularism, that the state exists, religious organizations exist. There may be levels where their paths may cross, but there should be no interference from each other. Then there is the issue of pluralism, religious pluralism, which the state may assume that in the nation there are a number of belief systems, and each of them should not be given any preferential treatment at all, and all should be recognized. But within it, there should be a certain level of coexistence, accommodation, and working together. So in this context, as to whether Ghana is a secular state, which we are, whether Ghana in terms of pluralism, for which we are, what is the remit? What is the scope? And the scope were not specifically mapped out in the Bonfe case. It just stated those principles without defining or mapping them out. There's secularism, for which the state ought to allow the existence of religions implied, that the state was free to give its support to any religious groups, or the state was to maintain a neutral position in respect of that. Technically, that was not delved into by the court. But it is my view that Article 21, Clause 1B and C, as well as 26 of the Constitution, was inspired not from the First Amendment to the American Constitution, but, as the earlier speakers have said, from the international arena, from a number of declarations and conventions under the auspices of the UN. And to know the scope and the limits of these religious articles, I think it will necessitate that we revisit some of these declarations and conventions for which Ghana drew inspirations from. And that will take us to the Universal Declaration of Human Rights that guarantee some of these. Everyone has the right to freedom of thought, conscience, religion, freedom of thought, conscience, belief. Does not permit of any limitation or restrictions whatsoever, as I did state, because this is what is termed as internal forum. And so you can believe or think that a stone is God. That is your belief. We call it internal forum. That a river is God. That the sun is God. That the cow is God. That is your belief. But when it comes to manifestation, how you manifest it, you openly display it. There may be restrictions that may be necessary to ensure that the rights of others are also enjoyed, or that may be necessary in terms of compelling justification for curtailing that right. And so, for instance, if somebody's religion is that he came to this world naked and therefore ought not to wear anything at all, and that he wants to enjoy this right of not wearing anything, not only in the privacy of his or her home, but that he or she should be allowed, even within public sphere, to go naked, whether in a school, whether in any meeting of public nature, whether in the market, whether in a public bus. The question is, such religious expression, this is not just a belief, it's moved to the level of expression. Should it be allowed by the state? Because the person is expressing and manifesting that religious belief. But we must note what the Article 21 Clause 4 itself states in the Constitution, that nothing in or done under the authority of or a law shall be held to be inconsistent with or in contravention of this article, to the extent that the law in question makes provision that is reasonably required for the purpose of safeguarding the people of Ghana against the teaching or encourages disrespect for the nationhood of Ghana, the national symbols and emblems, or incites hatred against other members of the community, except so far as that provision, or as the case may be, the thing done under the authority of that law is shown not to be reasonably justifiable in terms of the spirit of the Constitution. And so, the right to manifest one's religion, we will say, is not unbridled. There are restrictions placed on it. But the question is, how and to what level and to what extent do we restrict it? And that comes to doing a balancing act between the right that is at stake against other competing rights or interests of the nation. And sometimes it is very difficult to lay down one whole criteria for each case. But in most cases, it may be case specific, where each case would be determined on the facts of its own. And recently, we know we have also encountered this case, the recent case that was ruled in respect of the Achimota case, the governors of Achimota School, against the two students that had passed and had indeed qualified to be admitted to that school. And per the school's rules, they condition it that per the rules of the school, each student was to have his or her hair low. And on that basis, the student, as long as they had that hair, the dreadlocks, can't participate in lectures and classes. The Human Rights Court in its decision did a balancing act and found whether the rules of the school was enough justification to curtail the right to education by the students. And it concluded that looking at the rules of the school, it cannot trump over the right to education by the student, and that the claim to that religious exemption was genuine and sincere. And so the issue of sincerity and genuineness of the expression or manifestation of that right being asserted as a religious right was prominent in that case. At the moment, the decision is on appeal, and I do not want to say much about it. Safe to say that in terms of religious right, assertion of religious liberty, there is always a balancing act to do. The sincerity and the genuineness of the expression of that religious freedom may be one, and therefore somebody else who may also have a different haircut, not in the name of religion, but on the basis probably of a voguish way of life or a lifestyle, may not be permitted to have that haircut in the school. And the question of looking at it each on its own may become very material. And as I said, a number of these cases we are confronted with them. The issue of Muslim students in traditionally Christian schools and being compelled to participate in Christian religious worship without any exemptions. There is always the compelling necessity by the authorities, when the occasion demands, for an exemption to be made for these students without necessarily compromising the rules of the school, whilst at the same time guaranteeing the right, the freedom of religion of the students. And so for now, until I believe the Supreme Court pronounces on this, we will continue to grapple with these claims in our nation. But I believe going forward, it will not be long when we will authoritatively have a pronouncement in respect of these rights. Thank you for your attention.